Welcome back. In an unusual move this week in the Michael Flynn case, the presiding judge appointing retired federal judge John Gleeson to argue against the DOJ's motion to dismiss charges. But just 8 years ago, that same judge argued against denying the government from dropping a case, writing it would be an abuse of discretion to deny that motion. Here to discuss, former Whitewater independent counsel and Fox News contributor Judge Ken Starr. Judge Starr, thanks for taking time to join us this morning.
My pleasure. Good to be with you.
Ken, tell me, what is it that Judge Emmett Sullivan is doing that he believes John Gleeson, this respected retired federal judge and former Brooklyn prosecutor, to come in now?
Yes, it's inappropriate. I think it's unlawful. In our system of government, the decision of whether to prosecute and to drop a prosecution is entirely vested in the Justice Department and ultimately in the Attorney General. So it's inappropriate. I think it's unlawful. And it's unlawful, by the way, under the law of the D.C. Circuit, in which Judge Sullivan sits. Let's look at very briefly, what Attorney General Barr, who I know to be a person of integrity, did. When serious questions were raised about the legitimacy and the lawfulness of General Flynn's prosecution by the Bob Mueller team, he appointed a very respected United States attorney from St. Louis who had been unanimously confirmed to the United States Senate to take a fresh look at all the new evidence that's come in, evidence that apparently had been withheld from General Flynn's defense lawyers. And he then came to a conclusion and a recommendation and gave it to the Attorney General, namely, the prosecution never should have been brought in the first instance. The Attorney General accepted that. It's his responsibility. And with all due respect to Judge Sullivan, he's overstepping his bounds here. And Judge Gleeson was right 8 years ago in saying it would be an abuse of discretion for him not to accept the plea that had been entered into or to dismiss the charges that had been previously brought.
Well, you laid out so well. I want to ask you, though, Judge Starr, if that exculpatory evidence had been given to Flynn, could the government have met its burden of proof in the case?
I don't think so, because as I've read this motion to dismiss filed by Attorney General Barr through the United States Attorney, no. The interview in the White House on January 24th, first of all, the agents did not think that General Flynn was lying. But at a legal matter, that's the factual matter, but as a legal matter, the elements of the offense of a false statement to the FBI was not met, or they were not met, because of this very important thing, materiality. Even if there had been a false statement, it was not that terribly material or relevant to the prosecution. So the charges never should have been brought, and this has been a terrible injustice to General Flynn.
Your Honor, we got to leave it there. Thank you very much, Judge Starr, for joining us this morning. We'll find out what this judge in the Flynn case decides to do. Thank you, sir.